Hello folks, welcome back to the channel. Another wander to work. It's going to be the last day I think of this fine weather before another storm, or a bit rather just a wet one this time, kicks in. So I'll quickly grab another video as I wander along. Talking this morning about our rights versus our privileges, for want of a better word. Well, within the Constitution, various acts that align with our rights and freedoms as derived from our ancient rights and liberties, and they are in fact codified elements that cannot be changed. And the premise of this being that Parliament cannot grant to us rights that already exist as a privilege, or they cannot change a right into a privilege. And you could argue, and it has been argued, for example, the rights of an Englishman to use his conveyance to travel around in means that he doesn't need a driving licence to use his own car to drive about, as long as it's not for commercial purposes. The very nature of a licence being it allows you to undertake commercial activity. Now, I wouldn't recommend anyone ever try that in court. I believe someone has, or someone's used it with the police when he was stopped. Good luck to him if you've got deep pockets. But that is only one of the internet rumours, so how true that is, who knows. But it does ask or leave us with some interesting questions. The rule of thought being from scholars and governments over centuries is that actually we don't have freedom of speech, only what they tell us we're allowed to say. Whereas common law states that our inalienable rights, we are free to say what the hell we like. It is not an offence to cause offence. And some judges have upheld that, and others have gone along with the Parliament's option and used things like the 1998 Bill of Rights, which is just an interpretation of the EHCR. The Bill of Rights 1688 refers to freedom of speech and debates. It doesn't say freedom of speech or debates. And I would argue again that within that one sentence they're talking about our freedom of speech and then they're talking about Parliament. But it was interpreted as purely being Parliament's freedom of speech, which is wrong. But there is also the case that the US, which based a lot of their constitution on our constitution, our Bill of Rights, but they realised what a bunch of bastards the but you know, when it comes to freedom of speech, that's why the founding fathers in the US, they created their First Amendment, and one of the first things they added in as a codified element, because they knew only too well that the British would bastardise the law somehow, as they did over in England, to get their way and remove any of our rights. So they made sure theirs were set in stone, because obviously that didn't have inalienable rights from the get-go. It was a fairly new continent or a new nation. But we've had ours under the common law for millennia basically, and it's those rights that we need to protect. There's an argument, of course, and I'm personally in favour of our inalienable rights against the rights of, or interpreted rights of the law courts. My argument would be that our inalienable rights, our birthrights, are outside the jurisdiction of any law court, personally. Not everyone shares that particular view, but I think they're set in stone, not in the purview of courts. Courts need to restrict themselves to acts and statutes. And acts and statutes that infringe on our inalienable rights are void by default. Of course, that's me giving my opinion, my interpretation. Fighting it in a court of law, somewhat different. I'm not even sure what case, unless I said something inappropriate, that it might be, I might land myself in trouble. But it is one of those questions that seems to go on and on and on. But certainly within our Bill of Rights, it does affirm our customs and ancient rights, and as far as I'm concerned, that includes freedom of speech. What do you think? What's your opinion on this? Please feel free to leave a comment below. Thank you for watching. See you again soon. Take care.